Okay, we've got a good quorum of people. We've now got 15 attendees. So I'll hand it over to Brian and Alex.
All right. Well, let's get started. Hello, everyone, and welcome. And thank you for joining us on our webinar. This is the Introduction to the California Environmental Quality Act, also known as CEQA webinar, that's being hosted by Nevada County in partnership with Kimley Horn and Associates. My name is Brian Foss. I'm the Planning Director for Nevada County. And with me is Alex Jewell, Brad Stoneman, and Joe Clayton. And they are with Kimley Horn and Associates, which is a planning, environmental, engineering consulting firm. Alex and Brad will be giving the presentation in just a moment. It'll be about a 30-minute presentation. And the remaining time of the webinar will be a question and answer period. And there'll be some instructions at the beginning of the presentation on how to participate in the Q&A, how to raise your hand, and so that we can hear your questions. I do want to mention that the webinar is being recorded and it will be posted on the county website for future viewings and for anyone who is unable to attend live. Before I turn it over to Alex and Brad, I wanted to just give a brief reminder overview of the purpose of tonight's webinar, and that's to provide some education and some information to interested parties about the California Environmental Quality Act, about its rules and regulations, the process that's required for development and entitlement proposals, going through environmental analysis, the different timelines and different steps involved. Most importantly, the steps that involve public comment period and how to provide public comment. We are not talking about a specific project tonight, any past or future projects or any specific areas of the county. Again, this is meant to inform and educate about the CEQA process from beginning to end. It can be a lengthy process spanning a number of months and sometimes years. And so sometimes it's not always easy to follow or know exactly where a project is in the process and what opportunities might be available in the future to provide input from the public. So the purpose of the webinar is to try to give that 30,000-foot view of the entire step-by-step process, and most importantly, provide information about how to write and submit effective comments that will inform decision makers and jurisdictions on land use entitlements and projects approvals as they come through the county or even the cities. And so at this time, I'm going to turn it over to Alex to introduce his team and begin the presentation.
Thanks, Brian. Hi, good evening. My name is Alex Jewell. I am a project manager here with Kimley Horn based in Sacramento. I've been doing CEQA work as both a public agency planner and as a consultant for approximately 26 years and have worked throughout California, including some projects in Nevada County. Brad, you want to introduce yourself?
My name is Brad Stoneman. I work with Alex at Kimley Horn. I've been in the field for about 10 years and have worked on a number of projects in the county as well, and enjoy writing CEQA documents.
Thanks, Brad. And working behind the scenes with us tonight is Joe Clayton. He's a senior planner and will also be working as the meeting facilitator. And with that, Joe, you want to give us a couple pointers on how to for the question and answer session.
Sure, thanks, Alex. So for tonight, you will be able to use the raise hand feature and the Q&A feature. Just a minor technical snafu, as I was noticing earlier. If you could do us a favor, when you type in a question into the Q&A box or later in the meeting, if you use the raise hand feature, if you could just give your first and last name, or just first name if that's what you're comfortable with, it will help us with managing it. It's just, for some reason, everyone's coming up and showing us the same person. But the easiest way to get your questions answered tonight is to pop them in the Q&A box, and then we'll answer them during the Q&A session. Or if we have time, and hopefully we do, you can use that raise hand feature that's at the bottom. And again, just a reminder, if you can give us your name when you are asking this question. Looking forward to tonight's presentation.
Thank you, Joe. And then we will post this slide at the end again, so you have these directions. So we're going to begin our presentation right now. We're going to turn our cameras off, and we'll turn them back on for the Q&A session. So for our agenda tonight, Brian did a pretty good job outlining the presentation we have lined out for you. It's intended to be about a 30-minute presentation followed by an hour of Q&A. And as Brian mentioned, it's going to be an overview of the California Environmental Quality Act. That's the state law that governs the environmental process for most public and private projects in California. It is most commonly referred to by its acronym, CEQA. As part of that, we talk about agency responsibilities, the key participants and their responsibilities in the CEQA process. We'll talk about the main types of CEQA documents that are most commonly referred to and used in processing land use applications. And we'll also talk about the most effective way to review and comment on a CEQA document. And then following that, we'll have our Q&A session. And with this, I'll turn it over to Brad.
All right, hope everybody's doing well tonight. So what is CEQA? As Alex said, it's an acronym for the California Environmental Quality Act. CEQA is a state law that applies to discretionary actions taken by California agencies, state agencies, regional and local agencies. Discretionary action refers to a decision that requires deliberation or exercise of judgment by one of the decision-making body. At its core, CEQA is intended to be a disclosure document. That means CEQA requires the disclosure of potential environmental impacts of proposed actions or proposed projects. CEQA requires mitigation to reduce or avoid significant impacts that are found during the process. CEQA is not a permit. It's merely meant to inform decisions and doesn't approve a project or deny a project. It's very important to note, though, regarding the mitigation, while mitigation is required, that mitigation may not end up fully reducing impacts to a less than significant finding. In sum, the CEQA is a disclosure document. It's not intended to fix or eliminate all impacts associated with the project, and the EIR does not approve or deny a project. That is the responsibility of the decision makers and appointed elected officials. Next slide, please. So the CEQA process is tied to three different agency types. First is the lead agency. This is the agency with the principal responsibility for carrying out or approving a project. The lead agency is responsible for completing the CEQA document. Within Nevada County, unincorporated Nevada County, typically Nevada County is going to be the lead agency. A responsible agency is an agency that has legal responsibility for carrying out or approving a project other than the lead agency. Typically, a responsible agency will issue a permit or authorize or provide funding for a project. One example could be the State Water Resources Control Board, who might issue a permit for erosion control. Then you also have trustee agencies. These are agencies with jurisdiction over certain resources that are held in trust for the people of California, but they don't have legal authority for approving or carrying out a given project. This might refer to the California Department of Fish and Wildlife or State Lands Commission. Next slide, please. So again, going back to the intent of CEQA, CEQA process is used, again, to inform the decision-making process. As you can see by the chart here, the lead agency is in the center, and it's giving and receiving feedback from all the other listed agencies, responsible parties, and concerned citizens and organizations. For example, the lead agency is going to be working with and communicating with responsible agencies. Another responsible agency might be the Air Resources Board, who's concerned about air quality from a given project. So the lead agency is going to work with the Air Resources Board regarding potential impacts and considerations regarding air quality. Trustee agencies, again, they might be working with Fish and Wildlife. Fish and Wildlife has a lot of good resources regarding sensitive species, sensitive habitats within a project area. So they're going to work together and trade information to inform the decision-making process again. And then with that, on the bottom, you see the applicant. The applicant obviously has proposed a project, and they're going to be working with the lead agency and exchanging information. The lead agency is going to pass other information from other agencies to the applicant. They might want to adjust or amend a project to help reduce impacts or comply with a regulation that might be needed. The lead agency is also working with environmental consultants. Those might be people who are writing documents or writing an environmental impact report for the lead agency, but all this can also include specialists in terms of cultural resources or biological resources. And then you also have the concerned citizens and organizations. This is actually a very important process, or part of the process, in terms of gaining information and insight into a particular area. Oftentimes we'll receive comments and letters from concerned citizens who live in an area of a proposed project. And those folks, a lot of the time, are well informed about various resources and specific concerns of those residents to those areas. And we want to hear about that and include those kinds of information, or that kind of information, to the documents. Then, although the courts are not necessarily involved immediately with the process, they might be involved should a project eventually be litigated. Next slide, please. So CEQA is part of the entitlement process, and the entitlement process refers to the taking of a project to the point a project or property is able to be developed. CEQA is the CEQA document must be certified prior to a project being fully entitled. Next slide, Alex.
All right, thanks, Brad. Appreciate it. So I want to talk about the three main types of CEQA documents that would likely come up during a project application. And so there's three documents listed here, generally in order of least complex to most complex. So the first one is the categorical exemption. And these are projects that have been determined to be exempt from the CEQA process. When the law was written, the California legislature identified a series of projects, a series of classes or types of projects that were determined to not have an impact on the environment, and therefore were exempt from having to do the CEQA process. So typical examples of these are if you're working on an existing facility, a lot of times road repair work would fall within a categorical exemption. The next level of document is a negative declaration or a mitigated negative declaration. And this is, a little bit more involved in the categorical exemption and more streamlined than the EIR process that's shown below. In this process, you do have to do some analysis as part of the environmental review. You start out with a document called an initial study, and which includes an environmental checklist, and we'll talk a little bit more about that in a few slides from now. Then you have an actual document, and then that document goes before a hearing body, a decision-making body for approval. You'll notice that the squares that have an orange highlight, those are the squares in which the public is invited to participate in the process. So in the case of the mitigated negative declaration, when that document is ready for public review, it goes out for a 30-day public comment period, and the public is invited to provide comments on the document, whether they agree or disagree, and then those comments are included as part of the administrative record and included in or forwarded to the decision-making body for their consideration and their decision. The environmental impact report, or EIR, is the most robust of these documents. This is a document that takes the longest to prepare and is the most involved. It has the most required components of it that have to be addressed as part of that. And we're going to go into the EIR process in a little bit more depth in a few slides from now. But again, you can see that there's an added public participation component here with the notice of preparation, or NOP, and that's what's different about that from the mitigated negative declaration, is that the public is invited to participate in the scoping process. So you can comment on what you think needs to be considered as part of the EIR. So this is the CEQA process, and I realize this is a lot to take in on an online presentation, but it also points to the amount of decisions that are needed to be made with regards to which type of document that needs to be prepared, and starts with identifying whether the project qualifies for that CEQA exemption. If no, if it doesn't qualify for the exemption, then you do the initial study, and you can determine whether or not a project is appropriate, or the mitigated negative declaration or the EIR is the appropriate environmental document. Here's the general timelines for preparation. You can see that the exemption is by far the shortest process. That's 2 to 8 weeks, and it can even be less than that. Sometimes it just depends on how long it takes to get the information regarding the project description together, and in some review time. The mitigated negative declaration, or the negative declaration, and the difference between the MND and the ND is whether or not any mitigation is incorporated into the project. But that process can take anywhere from 6 to 9 months. And really what drives that whole process is if there's technical studies involved. And by technical studies, I mean, is there a project-specific study for air quality, or a project-specific study that evaluates biological or cultural resources that have to be prepared to support the analysis. And the more technical studies you have, generally the longer it's going to take to complete that process. And then there's the EIR, it's the Environmental Impact Report, and this is a process that can typically take between 1 and 2 years. Again, it's a much more robust document. It has, the additional public review period in there for the notice of preparation. It involves other parts like a cumulative analysis and alternative analysis, which we will discuss in a few slides from now as well. So it takes a while once EIR is determined to be required to complete that whole process. And with that, I'm going to turn this back over to Brad.
Thanks, Alex. So as Alex mentioned, the initial study, and going forward, in this presentation and future discussions, I'm sure you hear about CEQA. You'll also hear the term initial study. So the initial study is often the starting place for environmental analysis. So this is kind of where what we previously discussed was the process, some of the process behind the environmental process. This is actually where the analysis realistically, wholeheartedly begins. So as you can see, based on this CEQA guidelines, an initial study means a preliminary analysis prepared by the lead agency to determine whether an EIR or negative declaration must be prepared or to identify significant environmental effects to be analyzed in the EIR. Now note, it says whether an EIR or negative declaration must be prepared. You don't necessarily have to go through the initial study process. Just want to be clear that if the lead agency determines the CEQA guidelines allow for an agency to skip the initial study and go right to an EIR. This can be done for a variety of different reasons, such as if we know there's going to be significant impacts, or there's a profound amount of public controversy, we might go right to an EIR. So next slide, please, Alex. So within the checklist, we have 20 different resource areas. And the resource areas provide a pretty thorough review of all the different potential impacts that might occur. Within each resource area, though, it's not just these resource areas. There's a series of specific questions that are used to determine impacts and further define the resources and what impacts a project might have. And with that, we'll go to the next slide and give you an example of that. So for example, under aesthetics, you can see that there are the series of 4 questions. So for example, or not for example, under A, have a substantial adverse effect on a scenic vista, substantially damage a scenic resource, and not including but not included to trees, rocks, outcrops, and historic buildings within the state scenic highway. And then skipping down to D, create a new source of substantial light or glare, which would adversely affect day or nighttime views of the area. So you can see that just under this one resource area, aesthetics, the checklist provides a fairly broad base from which to begin the analysis. The analysis can, it should be noted that the analysis can vary though from each checklist item depending on the project in relationship to the resource area. So what's good about this, for example, depending on the type and location of a project, the impact classification can and will change. The impacts have a relationship to the environment in which a project occurs. For example, a project in a pristine area, say, there's lots of pristine areas, undeveloped areas in Nevada County. So impacts to scenic vistas would likely be greater there than in a larger city where everything's already developed. Or impacts to light and glare would be more noticeable likely in such an area than that of that of a city. So within the checklist, then, based on the answers to these questions and information that we have, we'll make a determination whether that impact is potentially significant, less than significant with mitigation, less than significant, or that there would be no impact. Next slide. So Alex had previously mentioned technical studies. These are generally the most common studies that we run into: air quality, greenhouse gas analysis, biological resources, historic, archaeological, cultural resources. Oftentimes we'll do hydrology and water quality analysis, or not analysis, but studies to back up the analysis in the initial study, and or further environmental document, transportation analysis, and noise analysis. Noise will vary again depending on the adjacent uses. So the number of studies can vary based on the types and complexity of the project. Urban infill projects will have different impacts and projects in rural areas, kind of like what we talked about before. Bio and cultural resources may not be required for an urban project, but likely required for more rural, undeveloped areas. Similarly, traffic and hazardous materials studies may be more likely in an urban area. So again, for these, a lot of the time, though, we'll want some additional detail. It won't just be base analysis, but we'll want some the technical studies for these types of projects.
Thank you, Brad. So I wanted to touch on a new type of analysis that started as part of the California Environmental Quality Act beginning in July of 2020. And that is the concept of vehicle miles traveled to assess traffic impacts. And vehicle miles traveled is a way of addressing traffic impacts, but it moves away from the traditional level of service impacts, in which level of service evaluated transportation impacts on a roadway or intersection, and it was more of a metric that was based on the volume of traffic against the existing capacity of that roadway or intersection, and how that intersection or roadway performed with the addition of project traffic. With vehicle miles traveled, you transfer that analysis from performance on the ground to emissions in the air. So vehicle miles traveled, you're assessing whether your project is going to result in cars traveling a greater distance than the county average, or if it'll reduce vehicle miles traveled compared to that countywide average. And so it's a fundamentally different way of assessing traffic impacts, and it's a relatively new process in some jurisdictions. And it's a different way of thinking. So I don't want to get too far into it, because we could do a full day conference on VMT alone. But I did want to note, though, that level of service may still be required by an agency, to help assess fair share payments for traffic, for roadway improvements, or if it's required to meet general plan policies. So here's the EIR process and the key steps, and go into this a little bit more in depth. As I noted before, the EIR process starts with the notice of preparation. And so that's the lead agency. In the case of the Nevada County, it would be the county issuing this notice that they've identified that an EIR is required for a project, and they're soliciting input from the public and public agencies to provide comments on what they believe should be included in the EIR analysis. And again, similar to the process charts above, you'll see the orange highlights. Those, again, are where the public is invited to participate in this process. Once the NOP is prepared, the environmental document, the draft EIR, is prepared, and this process may take, some time. This might be one of the longer steps in the process, as the document is drafted, the technical studies are drafted, they go through review. There may be several iterations of the document going back and forth in the review process. But when that review process is complete, it goes out for public review for a 45-day public review period. That's a minimum review period. Sometimes they can be longer depending on the project and the agency, but it's a minimum 45 days. There you can provide comments on the environmental document, and we'll talk about how to provide an effective comment a few slides from now. Once the agency receives those comments, they have to prepare written responses to those comments and findings. The agency has to prepare findings on why they've chosen to approve the project and adopt mitigation, and then that EIR gets certified. So the agency actually certifies the EIR, and as Brad mentioned in the very beginning, the EIR doesn't approve the project or deny a project. It's just a disclosure document. So the agency would certify that they've reviewed the document and that it appropriately discloses the impacts of the project. So here's some key considerations when preparing in reviewing an EIR, that it fully discloses the potential environmental impacts of the project, that those impacts are based on specific thresholds that, for which you can evaluate the degree of impact. And then based on that degree of impact, can you make a determination that whether or not they are significant or less than significant? For impacts that are potentially significant, identify feasible mitigation measures to reduce or avoid those impacts. And as Brad mentioned earlier, sometimes mitigation can avoid an impact altogether. Sometimes it'll reduce the impact. It may not reduce it completely, but it may definitely lessen the severity of the impact. And then sometimes you can have mitigation measures apply and the impact still remains significant. And so those are identified as significant and unavoidable impacts. And then, as I mentioned again earlier in the presentation, the EIR is also required to consider cumulative impacts. Cumulative impacts are where you look at the project impacts, and then there may be other projects in the surrounding area of the project that may have impacts as well. And while all of those impacts may be individually less than significant, you need to assess whether if you looked at them on a cumulative basis, would they be cumulatively significant? And then also, lastly, consider a range of alternatives. And we'll talk a little bit more about those alternatives. So project alternatives are ways that a EIR can look to see if you have significant impacts. Are there alternative designs or alternative locations to the project that you could have this project, and then you would substantially lessen a significant impact associated with the project? The alternative, though, must still attain most of the project objectives. So an alternative wouldn't be considered feasible if you avoided a significant impact, but after making those changes, the project still didn't represent any of the basic project objectives. And then when you're looking at alternatives, it doesn't need to consider every conceivable alternative, but there has to be a broad enough range of alternatives that the decision makers have a chance to evaluate possible alternative designs. And that reasonable range is not defined in CEQA with a specific number. It could be something that's different for every project. And then lastly, I wanted to note that an agency is not required to adopt alternatives, even if it does reduce a significant impact. But if they do that, they have to make specific findings as to why they've chosen to approve a project, in which case there may be significant impacts. So every project that has an EIR, the lead agency has to make specific findings as to whether the impacts have been reduced, whether or not, if they have not been reduced, if they are unavoidable impacts because the mitigation is outside their jurisdiction, or the impact still remains. And if they choose to approve a project with significant impacts and it can't be mitigated to less than significant, then there's specific findings that are made. And those findings are called Statement of Overriding Considerations. And the agency has to disclose that it approved this project, even though that there are significant impacts and there may have been potential alternatives that would have reduced the impacts, but the project has specific economic, legal, social, technological, or other considerations that outweigh the unavoidable environmental impacts. And those findings are included not necessarily as part of the EIR, but along with the EIR at the final hearing by the decision-making body. So here are some items that are not covered in a CEQA document, either an MND or an EIR, that are commonly, in my experience, you get these comments on documents and people that have commented want to know why this wasn't included, and the CEQA guidelines specifically exclude things that would fall under social and economic impacts. So those are things like crime, unemployment, property values, the profitability or project viability of a specific project. So those fall into a separate category. There's something that is under the purview of the decision-making body to consider, but they're not considered a CEQA issue. CEQA focuses specifically on the impacts on the physical environment, so not these social and economic impacts. Public controversy alone does not require the preparation of an EIR if there's no substantial evidence of a significant impact on the environment. And then also conflicts with general plan or zoning designations. As was noted in an earlier slide, the general plan and zoning consistency is part of the process of an entitlement and of the project review. But if those conflicts would not result in a physical impact on the environment, then they would not be considered as part of the CEQA document. So I wanted to highlight on a couple aspects of the CEQA public comment process for both the mitigated negative declaration and the environmental impact report. Both of these have public review periods in which the public is invited to participate. There's the MND, which is either a 20 or 30-day public review period. Most of the time, it's a 30-day review period. That timeline is dependent on the project and its location. And then for the EIR, you have the 30-day public scoping process, and then the 45-day public review period for the draft EIR. And then as like any project, you have the opportunity to provide comments to the decision-making body, and what body that is depends on the type of permit that's being processed for approval. So I wanted to spend just a few minutes here at the end of this presentation to talk about how to make an effective comments. You know, a lot of times people will make comments, and members of the public will make comments and be frustrated that they don't feel like their comments were properly responded to, and sometimes that's a result of the comment not fitting within the structure of the environmental document as it was intended. So to make an effective NOP comment, you know, there's a 30-day public comment period, and as part of this, you should avoid making comments that focus on the merits of the project. Really, the NOP process is structured so that the lead agency wants to know what should be considered in the EIR. What are the items that should be focused for analysis? And commenting on the merits of the project is really outside the scope of that, and doesn't help the county effectively scope their project. So examples of things that would make for an effective NOP comment would be if you're aware of dangerous roadways or poor sight distance at intersections. Those are things that the lead agency should know to look for or to include as part of their analysis. If there's sensitive plants or animals around that you're aware of, that should be noted. Flooding is one that I see a lot, and you know, people will note that, you know, if there's development on their project and it's right next to their property, that like when it rains, this area floods, and if developing a project there is only going to contribute to the flooding, then that's something that should be included in the analysis. And then also if you're aware of any historical or cultural resources around. So then that's part of the NOP. And then to make an effective comment on a CEQA document, similarly, you should avoid making comments on the merits of the project. You know, those comments should be sent directly to the decision makers. Again, as part of the comment on the document itself, it should highlight if there was analysis that you believe is incorrect, or if there's missing analysis. And what makes a really good comment is if you have some sort of evidence that can substantiate your comment. You know, this analysis that's in the EIR is insufficient because of these reasons, or you know, there's this dangerous curve that's in the roadway, and the traffic analysis doesn't include any evaluation of that. Something to that effect. And the courts have determined that fact-based comments from residents based on their personal observation and experience constitute substantial evidence. And so that's something that that should be included in the comment. And even better is if you can provide that information as part of the notice of preparation period. Generally, the level of detail that's provided in the comment is what's going to be reflected in the response to comment. So all the letters that come in as part of the public review process, the lead agency takes those, and the example here shown on the screen is a comment letter that was submitted to the county from the California Department of Fish and Wildlife. And so each letter is taken, and then within that letter, there may be you know, any number of individual comments. And so those are bracketed out, and then a written response is prepared for that specific comment. So it may not be unusual for one you know, 2 or 3 page letter to have 10 or 15 specific comments in it that need to be addressed. And again, as I mentioned before, when a comment comes in that's you know, focuses on whether the commenter likes or approves of the project, you know, that isn't really addressed as part of the comments, and that leads to a lot of frustration because people feel like they've spent the time to comment and written why they don't like the project, and if it doesn't focus on the analysis in the EIR, then there's usually going to be a general type of comment that you know, just says that the comment is noted and that it'll be forwarded to the decision makers for their consideration as part of the project. And so that concludes this part of the presentation. We ran a little bit long, so I apologize for that, but trying to cover CEQA in 30 minutes is a challenge. There's usually 2 or 3 day seminars on this, but we wanted to do our best to cover as much of this as we could and provide a good, solid introduction. So thank you for your time, and we are going to go into questions and answers, and I'm going to put that slide back up on how to, you know, raise your hand.
Thanks, Alex. I've been to some of those CEQA seminars myself, and you and Brad definitely did good credit and probably a bit more interesting than some of them. So we have a few good questions that have already been submitted via the chat. Paul, I'm actually going to unmute you, and please accept the unmute. And I thought maybe it'd be easier if you talk directly to Alex, Brian, and Brad. There you go.
Can you hear me?
We can.
Yes, sir. How are you, Paul?
Hi, good. So great presentation. I had actually 3 questions. What's typically included in the application to the lead agency where it's a project that you would expect the full CEQA process to unfold?
Yeah, I'll start off, and then Brian, I'll have you supplement anything specific to the county if you'd like. So typically, most agencies, the county included, have a project application form, and it includes some basic information about the project, you know, size, acreage. You provide a project description of what your project entails. Usually, there's a site plan that's required to be submitted that shows the layout of the project and where certain things are going to be located. Sometimes an applicant will provide some technical studies that they did as part of their due diligence process in preparing that. And so all that is taken into consideration. And, you know, if it's a really, you know, typically if it's a really large project, or it's a project that type of project that the agency has seen before, they can pretty well assess, if it's going to be a, mitigated negative declaration or an EIR.
Okay, thank you. During a time when we're all living with COVID and gathering is limited, how are we adjusting to the public input process and to the role of the citizen in these projects? I know that with the county, a lot of their meetings now are on Zoom. Same with Grass Valley. They both agencies are handling it differently, but it does seem like it's put up some really difficult roadblocks for citizens to be involved in the process. So I guess my question is, would probably be to Mr. Voss and to yourselves, how are agencies handling this so that they ensure that the public is having an opportunity to weigh in?
Sure, I can start. There have been some legislation passed down from the governor that identifies what some of the Brown Act requirements that govern public meetings, that has declared that those meetings can still occur in a virtual format. And so that's what the county has been doing with our public meetings for the most part over the last number of months. But all the steps in the process that we've talked about tonight, and all the general steps in a land use application with public noticing and accepting comments and providing written comments to decision makers has not changed. Obviously, we've held a number of meetings virtually and have identified a number of ways to provide comments to decision makers, whether written format or a format like tonight where we're taking comments live. We have also set up phone numbers to leave messages and phone-in numbers to participate live. So all the steps of the process have not changed or been eliminated. There's just different medium that is required to be used in order to convey the comments between the public and the decision makers.
I can jump in real quick. It's actually ironic or funny that I've actually, in the meetings and projects I've been working on lately, they've seem to be more well attended now, almost than previously, requiring the in-person attendance. I don't know. I think that might just be a function of people are able to log in real quick and attend a meeting, as opposed to having to drive to a council chambers or something like that. It's a hopefully, I wouldn't even mind seeing this process, the online process, continuing in conjunction with the traditional council meetings in person.
Is Nevada County, they're not doing theirs where people could join the Zoom? Is that correct? There isn't a Zoom meeting for Nevada County Planning Commission or Board of Supervisors.
Yes,
the public can join.
Yes, there is. The meetings are advertised, and there are links and ways to log in, watch every one of those meetings. We have them also recorded and up online, and so every meeting has been offered for public to view and provide comments on.
But they're recorded, they're not live, isn't that? That's my understanding.
No, they're all live.
Okay, good. My last question is, it had to do with the question of findings. So if an agency has a finding that there's an overriding economic benefit to the community, do they need to back that up with an economic study, or can it be just based on, I don't know, each of their own individual understandings of how they think it's going to go?
Yeah, the best answer for that question is it depends, and it depends on the nature. I mean, if it's a question like it creates jobs, then you don't really, I haven't ever seen a report that goes through and has to justify how many jobs it's going to create. Again, for a project, if it is supposed to generate X number of dollars of tax revenue or something like that, it generally doesn't get to that level of detail. Generally, when I've seen like specific economic studies, is if a project applicant says that they can't do certain improvements or something like that, then they may do some like high level pro forma or something like, or some sort of study like that. But generally, as a general rule, to make a statement of overriding finding of consideration, you do not, there's no technical economic report that's required.
Thank you.
Thanks, Paul. I'm now going to call on Pat. Pat, please accept the unmute, and there you go. Okay, there you go.
Can you hear me now?
Yeah.
Okay. Thank you very much. I appreciate this meeting. It seems to be on the back of my mind these days with some new work that I'm doing. And thank you, Brian, for also being here with our panelists. So my question is basically, this is not too discreet. When a mining operation is attempting to reopen a mine that's been closed for a while, and some folks feel that traffic and water will be affected, where is it that we can find that CEQA document?
Well,
Yeah, thank you, Pat. Oh, sorry, Alex, I was just going to jump in. We will post all of our CEQA documents on our webpage on mynevadacounty.com under the planning department. And so any CEQA document that's been completed will be listed under the project name. It depends on where the project is in the process. If the document has not been completed, then obviously there'll be nothing posted. However, we do post the application and the materials that were submitted with the application and any other appropriate documents that relate to where the project is specifically. So I would invite you to search our website, and you would be able to find information in the current status of projects that are in process currently.
Thank you, Brian. That seems a bit too easy to have realized. Thank you.
Thank you.
Folks, feel free to use the raise hand feature at the bottom of your screen if you have a question.
While we're waiting for the next comment, I did want to note that the county is going to provide this presentation both in its recorded form and also the slides that we've talked to tonight on their frequently asked questions page. There's a CEQA page, and I have that here at the end of the document. I'll do now just to give you the link. Whoops. The link down here. So the county has prepared a lot of responses to their frequently asked questions, and it's a good resource as well for questions about CEQA and the CEQA process, and it's very specific to Nevada County.
And just to add to that, Alex may have just mentioned it, but that's the location on kind of that front page where we will likely post this webinar as well as the slide deck. And that'll probably go up in the next couple of days. As this is being recorded, we need to get the final version and then hopefully post it within the next couple of days. So if anyone was not able to attend tonight, please feel free to forward that information along so that anybody that's interested can watch the webinar and take advantage of the resources that are on that FAQ page.
Thanks, Brian. We actually have a question that's just come in. Questioner, if you wouldn't mind just raising your hand and I can unmute you. There we go. There we go. If you wouldn't mind identifying yourself as well, that would be great.
This is Bob Brandstrom from Grass Valley.
Bob.
Did you see my written question? Is that what you're referring to? Yeah, the question is this. You had one slide that talked about 3 different kinds of agencies: the lead agency, responsible agencies, and trustee agencies. The following slide had a diagram that showed those 3 plus another group called agencies with jurisdiction required by law or something like that. Yes, at the top there. What is the upper one there with agencies with jurisdiction by law? What does that mean?
Yeah, that's so that could be an agency like you know, like Brad mentioned, the Air Pollution Control District, or maybe another city. It's not real common. We probably that they would be involved. So it's an agency. You know, it could be. Sometimes it's like an outside district. Like it could be like a water sewer district. It could be a police or fire department. That type of thing. That wouldn't necessarily be issuing permits on the document, but they have some role or some influence in the process.
Okay, thank you.
Thanks, Bob.
Maybe if as we're waiting for another comment, I just wanted to clarify the direct link would be mynevadacounty.com/CEQA is kind of the main page that this presentation and webinar will be posted on, and then on that page we'll have links to the FAQs and other information.
Mm-hmm. Any other questions, Joe?
None coming in. I guess everyone's going to get 30 minutes back of their night.
Okay. Brian, do you have any closing remarks you want to make, or if someone submits a question and we can maybe respond to it after the meeting or something?
Sure. Yeah. First of all, thank you to everyone that attended, and thank you to Alex, Brad, and Joe for putting together this presentation and working with the county to provide this information. And that mynevadacounty.com website under the planning department will have a bunch of information about current projects, all of our governing documents, such as our zoning ordinance and our general plan, and then also contact information of how you can contact us, email us, give us a phone call with any questions you have, either on this topic or anything that's under the purview of the planning department. We have a number of planners here, and we're happy to respond and answer your questions the best we can. And again, that's mynevadacounty.com.
All right, Thank you, everyone.
All right.
Is there
Thank
one-
you.